The Supreme Court today struck down Roe v. Wade in an opinion written by Sam Alito. In the opinion, Alito warns against a, quote, exercise of raw judicial power, explaining that he embraced this raw judicial power to strike down 50 years of precedent, to fight against raw judicial power, which brings us kind of to the history of how we got to this moment, because Alito, very squarely kind of grounds his overturning of Roe v. Wade in a history lesson that stretches back to the 13th century. So, Emily Jashinsky, do you want to? I want to respond to some of Alito's history, but I want to get your take on this first. What's your assessment of his kind of his ruling here?
Yeah, and I'll just first say, I don't think anywhere else in news are two people who disagree more on this issue sharing a screen in this really historic moment as Roe was overturned, whatever you think of it. And so I think, and I hope this will be a constructive conversation, because we had a great conversation about this, Ryan, when you walked through that judgment in your radar just a couple of months ago, or I guess a month and a half ago, as the Dobbs leak was put in Politico. You walked through the reasoning stretching all the way back to Cook and everyone else, that Roe was decided as though we had a right to privacy. So it's found in the right to privacy, in the Bill of Rights, that if you have a right to privacy, then you have a right to abortion. And what Alito does in this opinion, and in the draft opinion that we've known about now for some time, is say, okay, if you want to do that, if you want to root the right to abortion and the right to privacy, then there are two standards. You have to say, is this typically understood? And that's where he ends up going back to common law. Is this typically understood as privacy? And then he goes back to Cook and walks through the history of basically common law, which our judicial system is based on, and comes to a conclusion that we mentioned in a prior block, a lot of people even on the left have come to. And so that's where this is, that Roe was never rooted in the sound sort of philosophical judicial foundation, because that right to privacy is a tenuous one. Now, whether or not people have a fundamental right to abortion is a different question than whether Roe actually found the constitutional basis for that right. And so this is how you get something that's unthinkable happening, because Roe was always on shaky ground. And Ryan, I'm curious how you think the courts will kind of handle that going forward. Courts and states, as states try to craft their laws that codify Roe, that won't be subject to challenges like Dobbs was in Mississippi. How do you think blue states will start handling this question?
It's an interesting question, because it goes to the motivation of these Supreme Court justices, and whether you think that kind of this is their goal, that just overturning Roe v. Wade and leaving it to the states is where they're satisfied. But right. as Alito talks about, this is a deeply held moral question for people like him and for many Americans, and for people who believe that abortion is tantamount to murder. Then it's kind of absurd that you would say, well, abortion is murder, and murder's fine in California and New York. So I think this is not the end of the road. And I think that if blue states think that that they're going to be carved out of this move forward, I think they're mistaken, because I don't think that I don't think that the kind of Alito wing of this court is going to be restrained by, they've shown they're not going to be restrained by precedents or even by logic. And I feel like kind of a sucker getting into like parsing the history and parsing his language here, because I think this is about raw power, and I think that both sides are searching for the rationalizations for what for their the beliefs that they already have here. But I think it's worth going through it, because I think the gap between kind of the intellectual case and the historical case that Alito makes and reality is instructive, of how far he's willing to go. And so what we didn't have before was the dissent. And so obviously the dissent is from the 3 liberal justices who remain on the court, or who were on the court at the time. No, go ahead.
Justice Roberts filed a concurring opinion, but he did not join the majority opinion. So overturning Roe is sort of like 5-3-1, and Dobbs that's one way to think of it, actually.
But he concurred that it should be overturned, basically, right?
Yeah, 4-3-1.
Right.
Yeah, exactly. Yep.
Interesting. Okay, so to read from the dissent here, so they write, second, and we can go back to what their first point was. Second, and embarrassingly for the majority, early law, in fact, does provide some support for abortion rights. Common law authorities did not treat abortion as a crime before, quote, quickening, the point when the fetus moved in the womb. And early American law followed the common law rule. So the criminal law of that early time might be taken as roughly consonant with Roe's and Casey's different treatment of early and late abortion, and that goes back to what Roe called the viability standard. So, what they called it, what George Washington would have called it was pre-quickening, and what Roe called it was viability. And in both cases, that was not to be criminalized. It was the woman's right to choose what to do with a pregnancy, pre-quickening or viability. And so Alito has written this 1,000-year history, because he literally goes back to the 1200s for some of this. And he just kind of slides past the fact that abortion in common law and in early American law was legal. Now, he leans heavily on the fact that in the 1800s, you started to have some criminal laws put into place. Of course, women couldn't vote then. And so women get the vote in 1920, 50 years later. We've enshrined Roe into law. So how does Alito and how does the kind of conservative kind of intellectual movement around here square the fact that pre-quickening at the time of the Bill of Rights, abortion was legal? How does he square that with his claim that abortion's always basically been illegal and there's no kind of fundamental foundational history of that in the United States?
Well, when the right to privacy was enshrined in the Constitution, I think actually this was in the draft opinion, when the right to privacy was enshrined, I believe abortion was illegal. And I'll double check that in like many places in the United States.
Half the country, a significant number of the country, right?
Right. And so this question of whether the right to privacy, and this is what Roe gets into, because Roe cites Cook as well. The English common law goes back hundreds of years and cites English common law because it has to prove that this is historically understood as a right to privacy. And so I think that's where Alito comes in and says, well, when the Fourth Amendment becomes law, then this is what the country looked like. And so I think that's sort of how the evolution makes sense from the conservative perspective. But I would also say from the conservative perspective, Roe is just in and of itself not the topic at hand. As you just mentioned, if you're like me and you believe that abortion kills a life, then this question of privacy doesn't even make sense. And so I think that's sort of where some of the disconnect in the conversation is. And Roe itself was just such an odd way to get to this, that it was, it's been confusing for years, decades because of that.
And so, so to your point on when the 14th Amendment was implemented, the dissent writes, the majority makes this change based on a single question. Did the reproductive right recognized in Roe and Casey exist in, quote, 1868, the year when the 14th Amendment was ratified, unquote? The majority says yes, and with this much we agree, that the answer to this question is no. In 1868, there was no nationwide right to end a pregnancy and no thought that the 14th Amendment provided one. Alito is saying everything hinges on whether or not there was a abortion right, federally guaranteed abortion right in 1868, the year that you had the 14th Amendment, and the dissent says, well, no, but that's not remotely the point. That it had been, and nobody really thought that necessarily was the thing that was legalizing abortion nationwide. So where do you think they do take this from here? And so in Oklahoma, for instance, they're now trying to ban what they're calling abortion after fertilization. And so fertilization, as everybody knows, or if they don't know, they can Google, comes before implantation. And so oftentimes in normal methods of birth control, IUD, birth control pill, what those methods of birth control do is they don't stop fertilization. What they stop is implantation. And so is that, where are we heading next here? Now, I mean, and I don't want to say that where we're heading next is more important than where we are now, because for millions of people now, they have just lost the right to abortion, like as of today.
Yeah, no, I mean, it's absolutely true. Although if they live in many states, they still have that right, because Roe just does turn it back to the states. That is a really, really, really important element of all of this that you just highlighted, because even the morning after pill, it's unclear whether that prevents implantation in certain cases. And this may sound technical, and it may sound completely off topic, but it's really not. This question of implantation and fertilization, it's even IVF is now going to be on the table. These are discussions that have not been really at the forefront ever, that are now going to be thrust into the spotlight because state laws are going to have to talk about defining life in a very granular and particular way, because we have these sort of technological advancements, whether it is IVF, whether it is birth control, which we don't think of as a technology, but in the way that women, most common forms of it that women take now, are fairly new. And that's going to, this question of implantation becomes a huge one. And the thing I'll say on that is a lot of people on the right, we talked about this in an earlier block, are not prepared to reckon with the consequences of a post-Roe world. They have never really wanted Roe overturned, and they didn't understand, or they didn't want the implications, because the implications are deeper than some folks may have realized. Because if that's where we are, then you're going to have these state laws on the table, and so this is going to be, to the surprise of many people, I think they're going to find this will be a very bitter fight on the right. And Ryan, I don't know about you. I think this is setting us up for the rest of the summer to be perhaps a violent one, and people should be protesting, celebrating, whatever they're doing. I think that will be a sight to behold, and it will be, it'll look a lot like America. But I also do worry that this is so sweeping. It'll be a bloody summer, frankly.
Yeah, and the new name for the post-Roe world now is the world, and so just to run through quickly for people who are concerned, these are the states with the trigger laws. This comes from the Washington Post. You can find this. So Idaho has a trigger law, so that says that 30 days from today, abortion is banned. I don't know the details and what exceptions they might have in there. Utah has a trigger ban that takes effect within just a couple of days. Their general counsel has to certify it. Wyoming has a trigger law. It takes effect within 30 days. North Dakota within 30 days. South Dakota, that takes effect immediately. And so, like, as of now, abortion is being banned in South Dakota. Oklahoma, basically, they already banned it. Texas basically has already banned it, but they also have a full trigger law. Missouri has a trigger ban that takes effect just within days. Arkansas, as soon as their attorney general certifies the Supreme Court decision, the ban goes into place. Louisiana has a trigger ban that goes into effect immediately. Tennessee, 30 days. Kentucky goes into place immediately. Mississippi has one that goes within days. Alabama, Georgia has a 6-week ban that's from 2019 that is pending this. So they will presumably go to the Supreme Court, and Supreme Court will then rule on whether or not the 6-week ban is constitutional. Because now when you get to 6 week, a lot of people don't even know they're pregnant, depending on when you count. by 6 weeks. So what they're trying to do is, carve out exception. Well, we talked about implantation. That's a different question. But if you're down to 6 weeks, that's basically like once you know you're pregnant, it's too late to do anything about it. South Carolina also 6-week ban. West Virginia a ban. Ohio, Indiana, Iowa. Obviously, people can go to the Washington Post, or you can just Google around and find out. But we're not waiting around for the implications of this, because many of these red states have already enacted bans, just waiting for this moment to come. So we'll be discussing this more, I'm sure, soon. We have to leave it there for now. We'll have more rising in just a moment.